This is the first of two lectures on public welfare offenses. In this lecture, I'm going to focus on what it is that distinguishes public welfare offenses from true crimes and why the distinction matters in practice. As a practical matter, the biggest reason to worry about the distinction between true crimes and public welfare offenses or regulatory offenses is fault. The presumption of subjective fault that's set out in ADH does not apply to regulatory offenses. Furthermore, different fault standards are available in the context of public welfare offenses. Indeed, public welfare offenses can have no fault requirement at all. They may be what we describe as absolute liability offenses. And this is why, when we were looking at voluntariness, many of the cases concerned public welfare offenses, because many such offenses require no proof of fault. There was clearly thought to be a need to argue lack of voluntariness instead. What are some examples of regulatory offenses? Well, we might look to health and safety legislation, setting out the specific number of times in which one must have machinery inspected. We might imagine food safety standards, setting out specifically how long you can sell ground beef, or setting out specifically how it is to be labeled. We might imagine fisheries legislation, setting out the precise minimum size of lobsters that you are permitted to catch. And we might think of traffic safety laws concerning how fast you can travel in your car. Now, in part, what should jump out at us about public welfare offenses as distinct from true crimes is who makes them. We know from the very first day of class that only the federal parliament can create a true crime. And the federal parliament can also create public welfare offenses. But many public welfare offenses are made not by the federal parliament, but by the provincial legislature. And what's more, public welfare offenses may be made by bodies that are simply empowered by the relevant legislature to make them. So, in part, public welfare offenses are distinguishable from true crimes on the basis of who can make them and who does make them. Students often have trouble distinguishing public welfare offenses from true crimes because, at least on a superficial level, a lot of public welfare offenses bear superficial similarity to at least objective fault true crimes. I mean, consider that when you're talking about, for example, traffic safety laws, or when you're talking about health and safety regulations, what we're talking about here, of course, are regulated activities. Furthermore, what do these provisions do? The examples I just set out a moment ago. Well, they target a lack of attention or failure to meet some legal duty. Right? That's what these regulations often do, is set out a legal duty for motorists or for people who are operating factories or for people who are selling meat or for people who are catching lobsters. And they say, if you fail to discharge this duty, you are guilty of an offense. This makes public welfare offenses start to look, at least again on a superficial level, very like objective fault true crimes. But it's only on a superficial level, because let's look a little bit closer at how differently these two types of offenses operate: public welfare offenses, objective fault true crimes. And we'll do that first by just focusing in on one easy example. We'll compare the offense of dangerous driving with a traffic safety provision prohibiting drivers from going more than a fixed speed in certain zones. So our first offense, our offense of dangerous driving found in the code, targets your failure to give adequate care and attention in the context of a dangerous activity, motoring, leaving it to you to use your judgment as to what the conditions on the road demand, on the basis that it is intrinsically wrongful to engage in a dangerous activity like driving without paying due care and attention and responding to road conditions appropriately. By contrast, our traffic safety offense, don't go more than, say, 100 kilometers an hour on this stretch of highway. That simply states that you cannot drive more than 100 kilometers per hour in this zone. Now, is this provision also designed to promote road safety? Absolutely. But notice what it is not doing. It is not giving you any room to exercise individual judgment as to whether or not to go above 100 kilometers per hour in that zone. It's not doing that at all. It's an offense pursuant to the Highway Traffic Act or whatever legislation applies in your province to go more than 100 kilometers in that zone, whether or not it's unsafe to do so. There may be no one else on the highway. And yet, it will nonetheless be an offense under the public welfare offense provision to go more than 100 kilometers in that zone. And what does this tell us? Well, it tells us, for one thing, that the public welfare offense, though it protects and promotes public safety just as the true crime does, that it operates by essentially foreclosing your use of judgment, rather than setting out what sort of broad moral conditions should guide your judgment on the road. In a sense, the public welfare offense doesn't want people to use their judgment. And so it targets conduct that may not be intrinsically blameworthy at all. And again, consider this, the element of arbitrariness that's often found in regulatory or public welfare offenses. Is there anything intrinsically more blameworthy about driving along the highway at 110 kilometers an hour as opposed to 100, or 101 kilometers per hour as opposed to 100? Is there anything intrinsically more blameworthy about having your industrial machinery inspected every 31 days as opposed to every 30 days? Or every 61 days as opposed to 60 days? No, of course not. Of course, there's nothing intrinsically more blameworthy about one than the other. There's an element of arbitrariness in that line drawing exercise. The point of the regulatory offense is to set a line and to thereby ensure that people who are running factories, catching lobsters, driving down the highway, don't feel, as it were, entitled to simply exercise their judgment. We want to basically set hard lines on those who participate in those practices. By contrast, there is nothing arbitrary about the offense of dangerous driving. It is, we might say, intrinsically wrongful for a person to engage in a dangerous activity like driving without paying due care and control to their surroundings and to responding appropriately to those surroundings. So whereas there's an element of arbitrariness and judgment suspension, we might say, to regulatory or public welfare offenses, that's not true for true crimes. With all this in mind, it's no surprise that this distinction between public welfare offenses and true crimes has important implications for fault. Subjective fault will often be inappropriate in the context of public welfare offenses, since the point is to get people to act in ways that will minimize risk. And if people aren't thinking about what they're doing, well, then the regulatory scheme devised by your elected representatives, or as it were, their delegates, to guide and promote public safety, that scheme will be compromised. It also, however, makes less sense to speak about reasonable people, as we would in the context of objective fault true crimes. Since reasonable people, of course, will act in a way that is responsive to all the circumstances. Well, in the context of public welfare offenses, there's only one circumstance really that we think people should be paying attention to, and that's the directive set out in the regulations. Again, the fact that a reasonable person in the abstract might look at that piece of industrial machinery and think to him or herself, well, look, that machine hasn't even been used for the past 30 days. There's no reason on earth to think that there could be any problems that have developed in that machine in the interim. It's perfectly sensible for me not to go to the cost of having that machine inspected, or at least to wait another month or so to do it. No, that's one thought too many. For the purposes of the regulatory scheme, we may say to ourselves, we don't want you to approach your role like the reasonable person in the abstract. We want you to approach the decision to have that machinery inspected from the point of view of someone who is highly attuned and exclusively attuned to the requirements set out in the regulatory scheme that applies to you. So if you're a driver on the highway, we want you to pay attention simply to the maximum speed limit set out. If you own a factory, we don't want you to spend your time thinking about whether or not the circumstances, all things considered, require this machinery to be inspected right away. We want you to pay attention to one thing, and that's what the health and safety regulations require you to do. If you are selling ground beef, we don't want you to be approaching your task as you ask yourself, okay, well, can I continue to sell this ground beef? We don't want you to think, do even ask yourself the question, does that ground beef look okay to you? Does that look like it's still safe? Well, it seems fine. No. Again, that's one question too many. What do the regulations tell you to do? The end. So as this suggests, the usual fault requirements that we see in the context of true crimes will at least often, I don't say always, but often be inappropriate in the context of regulatory or public welfare offenses. The intention underlying these public welfare offenses is very much to promote and protect public safety, in large part by requiring participants in regulated spheres to suspend their judgment on various matters and simply do what we tell you. Now, many of the ideas I've been articulating here are found, albeit in somewhat messy form, in Mr. Justice Corey's opinion in Wholesale Travel. But the case that really dominates the landscape for public welfare offenses is Sault Ste. Marie. Now there, Mr. Justice Dixon emphasized that in the context of a regulated activity, it would often make little sense to require proof of subjective fault, since this would allow people to escape regulatory burdens by simply saying, "I forgot," or "I wasn't paying attention." The point of regulatory or public welfare offenses isn't to blame people, but simply to make risk-enhancing practices more costly for participants in the industry or field. And for this reason, there often is no language of fault in the regulatory provisions or in the offense-creating statutory provisions. And yet, Mr. Justice Dixon continued, it would surely be problematic to punish people for non-blameworthy conduct. And of course, if people can't help but violate the terms of the offense, whatever it is, what good does it do to punish them in the first place? On this basis, Mr. Justice Dixon found that neither a presumption of absolute liability nor a presumption of subjective fault would be appropriate for public welfare offenses. Instead, Mr. Justice Dixon held, we should presume that public welfare offenses have the, as it were, halfway house of strict liability. What's strict liability? Well, on proof of the actus reus, the defendant will have an opportunity to show on a balance of probabilities that he or she, or if it's a corporation, it exercised due diligence. That is, that all reasonable care was taken to avoid engaging in the prohibited act, in light of facts reasonably believed at the time. Now, so stated, the fault requirement of strict liability can at least sound a bit like objective fault, particularly that language of reasonableness, right? But notice a few things. First, in the context of objective fault true crimes, it's the Crown that bears the burden of proving that the defendant acted unreasonably, that the defendant's conduct was a marked and substantial departure from the norm. In the context of strict liability offenses, it's the defendant who bears the burden of showing that he or she or it did take all reasonable care to avoid engaging in the prohibited act. So partly there, I want you to focus on the difference in the burden of proof, but also focus in on what we are asking. We're not simply asking whether the defendant acted reasonably at the time. As I said a moment ago, it may be that if we were in an unregulated world, that the reasonable person wouldn't have acted in the manner that these regulations require us to, right? It may be that in an unregulated world, the reasonable person would have concluded that, sure, it's safe to wait 60 or 100 days to have that machinery checked. It's safe to drive 110, 120, 130 kilometers per hour in this zone. We are not asking whether or not the defendant acted reasonably in the abstract. We're asking whether or not the defendant took all reasonable care to ensure that he, she, it complied with the requirements set out in the regulation or in the act. So the question isn't, for our, say, factory owner, the question isn't, was it reasonable under the circumstances to wait more than 60 days to have your machinery inspected? The question is, did you do everything that could reasonably be expected of you under the circumstances known to you to ensure that you'd get your machinery inspected within the 60 days set out in the provision? And notice that's a big difference. What role does strict liability play going forward? Well, once we find that an offense is a public welfare offense, more on identifying these in a moment, there is a presumption of strict liability. Does that end the matter? No, because the presumption may be rebutted. How do we go about rebutting that presumption? We look to statutory interpretation. If the offense in question uses language of subjective fault, then the presumption of strict liability will be effectively rebutted, and the fault requirement is one of subjective fault. Furthermore, we might, using principles of statutory interpretation, conclude that actually the appropriate fault requirement for this offense is absolute liability, in which case the presumption of strict liability will again be rebutted, but it'll be rebutted downwards to one of absolute liability and essentially no fault.